I am Paolo Tamase of the college's Constitutional Law faculty. Welcome to Justice Carpio's lecture on Philippine Island Territories in the West Philippine Sea. This is the second event of the Magister Lecture Series, which began in June this year with Justice Vicente V. Mendoza's lecture on the art of free society. Magister is envisioned as a series of engagements with acknowledged pillars of political law and its related fields. These are recorded so that they may be opportunities to connect with and learn from those who have influenced the direction and development of legal thought in the country. The Malcolm Foundation, Constitutional Law Cluster, and the IBP Law Journal are grateful for the attendance of esteemed colleagues in all three branches of government and the academe, and their friends from foreign missions. We extend a special welcome to the members of the Armed Forces of the Philippines and the Philippine Coast Guard, who can attest to the real physical implications of the political and legal disputes in the West Philippine Sea. To start today's proceedings, I would like to call on our Master of Ceremonies, Dr. Lee P. Garcia of the Constitutional Law Cluster.
Good morning, and welcome to the UP College of Law and the Magister Lecture Series organized by the UP College of Law Constitutional Law Cluster and the Justice George Malcolm Foundation in cooperation with the Integrated Bar of the Philippines Law Journal. Before we begin, we would like to acknowledge the presence of our special guests. The trustees of the Malcolm Foundation, Justice Conchita Carpio Morales, Supreme Court Associate Justice Retired, Chair Grace Pulido Tan, former chairperson of the Commission on Audit, Dean Pacifico Agabin, former Dean of the UP College of Law. We'd also like to thank our executive department officials who are joining us on site and via Zoom, Undersecretary Carlos Sorreta, Undersecretary for Multilateral Affairs and International Economic Relations from the Department of Foreign Affairs, Undersecretary Eduardo Jose de Vega, Undersecretary for Migrant Worker Affairs, Department of Foreign Affairs, Francis Jude Lawenco, Assistant Director General for Partnerships and Engagement from the National Security Council, Attorney Fretty Ganchoon, Head, Maritime Group of the Department of Justice, the Office of Legal and Legislative Affairs from the Department of National Defense, Office of Plans and Programs from the Department of National Defense, the Office of Strategic Assessments and International Affairs from the Department of National Defense. We also have representatives from the Congress, from the Office of Senator Francis Tolentino, and representatives from the Uniformed Service, Colonel Roderick Guerrero of the Philippine Navy, representing Vice Admiral Toribio Adasi Jr., Flag, Office in Command of the Philippine Navy, officers and cadets of the Philippine Coast Guard, officers of the Judge Advocate General Service, and we're also very grateful for the presence of our foreign mission here today. Ms. Karela Vera from the Deputy Head of Mission, the Embassy of Finland, Mr. Dalibor Mika, Deputy Head of Mission, Embassy of the Czech Republic, Mr. Colleen Townsend, Counselor, Political and Public Affairs from the Embassy of Canada, Mr. William Jensen, Head of Political Affairs from the Norwegian Embassy, Ms. Christelle Jovenier, Political Advisor from the Embassy of New Zealand, Ms. Eva Victoria Oskam, Political Secretary, Embassy of the Netherlands, Mr. Jamie Reyes, Political Officer of the Embassy of Netherlands, and Ms. Carly Norman from the Australian Embassy. To formally begin our program for today, may we request everyone to rise for the singing of the Philippine National Anthem.
Lupang
seated. To give his opening remarks, please welcome Professor Edgardo Cardo Elvistan II, the Dean of the College of Law and Chancellor of the University of the Philippines, Diliman.
Thank you, Lee, and good morning to everyone. Welcome to the UP College of Law for the second iteration of the Magister Lecture Series sponsored and organized by the Malcolm Foundation. This is the UP College of Law is honored and privileged to be part of this lecture series, and equally honored and privileged because we will have this morning someone we all know, very prominent public figure in the Philippine government, a former senior associate justice of the Supreme Court, who on his own took up as part of his scholarship the research and study of the West Philippine Sea territories. Even before he retired, he has been deeply involved in this particular matter, and he will be sharing with us this morning the product of his research, his analysis, and his insights into the matter. For our younger generation of law students, perhaps you might be wondering why, for some islands, islets, and even rocks, as we will technically call them, so near the Philippines, why there are disputes over their ownership. Isn't it quite natural that this should be ours, considering their proximity to our main islands? The problem is we find ourselves in a legal regime that is dominated by colonial norms, norms developed when all parts of the globe was up for grabs for colonial powers, and we haven't really, as an international community, we haven't moved on from that. That is why we have this problem that other countries are claiming formations or islands and similar formations very close to our main territory, our main islands. Even then, Justice Antonio T. Carpio has met the challenge of establishing a very, very strong and convincing case for our country, despite the prevailing norms being, I would say, skewed against former colonial territories like the Philippines. And this is what we will hear this morning. So I think everyone is waiting for what our guest speaker has to say. And I will not keep this opening remarks much longer. But I just want to, as my last point, I'd like to share the significance, or at least some of the effects of this issue, of what efforts, researches, and studies like that people like Justice Carpio has brought about. So in the University of the Philippines, under the current administration of President Angelo Jimenez, he has proposed, and the Board of Regents has approved, a new constituent university, a virtual one similar to our Open University, that will focus on archipelagic studies. So it is a recognition, perhaps most likely brought about by these recent issues in the West Philippine Sea, that in a way we have maybe neglected as an academic endeavor our inherent characteristic, our national characteristic as an archipelago, and what this means for us, not only in the legal domain, but also in the social and scientific domains, maritime domains. So because of the efforts, because of the, I would say, pioneering work of people like our guest speaker, our lecturer for this morning, Justice Antonio T. Carpio, we are doing this now in the University of the Philippines. And let this be remembered as the occasion when we can connect all those dots. No? Why this new program is connected to what we will witness and what we will hear this morning. So with that, I again thank you all for attending, our in-person participants as well as our online participants. And I wish you will pay close attention and really listen to what our lecturer has to share with us. Thank you very much, and I wish you all a pleasant and very productive morning.
Thank you, Chancellor Vistan. We'd also like to acknowledge the presence of our first lecturer during the Magister Lecture Series, Justice Vivi Mendoza. Welcome, sir. To introduce our distinguished lecturer for today, let's all welcome Professor Alfredo B. Molo, the Chair of the Constitutional Law Cluster and Editor-in-Chief of the IBP Law Journal.
Wow. So we have full house today. Good morning, everyone. Excuse me. Our speaker has been called the best Chief Justice we never had. Not just by lawyers, but by his fellow justices in the Supreme Court. What more can we add to that? His resume is publicly available, so today I'll share with you some little-known facts about him instead. He was, especially for the young people here, he was Chief Presidential Legal Counsel during the time of President Ramos. Some of you may recall that it was around this time that Mischief Reef was taken by China. That event in 1995 and the country's reaction shaped Justice Carpio's views moving forward. According to the late Secretary of Foreign Affairs, Albert Del Rosario, as early as 2011, Justice Carpio had already anticipated Beijing's unilateral action in the South China Sea. This is largely true, except for a small fact. You see, Justice Carpio actually started even earlier. Now, I know this because I personally witnessed the meetings he held with legislators, national and military leaders. Ultimately, however, he realized that China was just too powerful and no one wanted to speak against it at that time. Left with no other alternative, he did it himself. As early as 2014, economist Solita Monsod wrote that Justice Carpio was primarily responsible for debunking China's, and I quote, historical lies. Which brings me to my second point. He is a true patriot. I say true because he takes on causes and fights the good fight even if doing so costs him personally. His ruling on the infamous Lambino versus Comelec case during the time of President Arroyo practically cost him the chance to become Chief Justice. But he didn't learn. Several years later, he was again nominated for Chief Justice, but President Xi Jinping was in the country. If Justice Carpio just kept quiet, his chances of getting appointed by his fellow Davaoeño would increase. So what did he do? He spoke in Congress, he spoke in Ateneo, he spoke in UP and other forums because it was important for the country. When the arbitral award came out in 2016, Justice Carpio did not join the rush to claim credit. Instead, he was thanked by then Solicitor General Jose Calida, who joked that he will name a rock in the WPS after Justice Carpio. Secretary Del Rosario added that this country owes him, and I quote, an incalculable debt of gratitude for being its staunchest defender. You see, Justice Carpio continued his crusade even if it was politically unsafe to do so, such as during the Duterte administration. While others stayed silent, Justice Carpio persevered. Ultimately, President Duterte challenged him to a debate, which Justice Carpio immediately accepted, but the other party backed down, so we didn't see that debate happen. I end with one other fact, and that is we owe Justice Carpio much more than what we realize. Today, we equate him with protecting Philippine interests against China. But much of what we enjoy today is because of this man. For example, cheap airfares. The country's airline industry used to be a virtual monopoly. Justice Carpio, as Chief Presidential Legal Counsel, opened up the airline industry. Now everyone can fly. Another is inter-island shipping, or RORO. That was also Justice Carpio during the time of Ramos. And of course, the crown jewel, telecommunications. Justice Carpio is the chief legal architect who brought down the telco monopoly in the 1990s. He made it possible for new players to come in. And without these reforms, BPOs wouldn't have been able to boom, and the economy would not have taken off. We would all be probably still waiting for a landline. These examples are proof that when Justice Carpio speaks, he speaks for the Filipino interest. Ladies and gentlemen, our speaker, former Senior Associate Justice Antonio Tirol Carpio.
Please be seated. I'll have to sit down because age has caught up with me. Thank you, John, for that very kind introduction. A pleasant morning to everyone. I wish to thank the UP College of Law, headed by Chancellor and Dean Edgardo Carlo Vistanda II, and the Malcolm Foundation for hosting this lecture. And I wish to thank everyone present here for attending this lecture. I wish also to thank our online viewers for watching this lecture. In this lecture, we will answer the question, what are the island territories of the Philippines in the West Philippine Sea, and why does the Philippines have jurisdiction over these islands? We start with the 1935 Constitution, the article on national territory. It says that the Philippines territory, are the territories ceded to the United States by Spain in the Treaty of Paris, so that's one treaty, together with all the islands embraced in the treaty concluded with Washington, that's the 1900 Treaty of Washington, the second treaty, and the third treaty, the treaty concluded between the US and the UK, demarcating the boundary between North Sabah, the British North Sabah, North Borneo, and the southern Philippines. So the 1898 Treaty of Paris ceded to the United States, and I quote, the archipelago known as the Philippine Islands, lying within the Paris Treaty lines. The 1900 Treaty of Washington clarified that Spain also ceded to the US any and all islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. And the third treaty with the UK demarcated the boundary and everything on the side of the Philippines, all those islands belong to the Philippines. And the treaty with the UK also defined the Philippine archipelago as the territory acquired by the US under the Treaty of Paris and under the Treaty of Washington. We go to the next constitution, the 1973 Constitution, and it defines Philippine territory as the Philippine archipelago with all the islands and waters embraced therein. The Philippine archipelago means islands of the Philippines, means islands of the Philippine archipelago lying within and outside the lines of the Treaty of Paris. So it's very clear that when you speak now of the Philippine archipelago under the 1970 Constitution, we're saying that the Philippines territory comprises of the islands within and outside the Treaty of Paris lines. The same thing with the present Constitution, the 1987 Constitution. The Philippine territory comprises the Philippine archipelago with all the islands and waters embraced therein. It refers, of course, the Philippine archipelago means the islands of the Philippine archipelago lying within and outside the lines of the Treaty of Paris. Now, the question is, what are the islands of the Philippine archipelago lying within and outside the lines of the Treaty of Paris? The islands lying within, that's very easy to see, but the islands lying outside the lines of the Treaty of Paris, what are these islands outside the lines of the Treaty of Paris? Well, we have to look at the Philippine archipelago, the term Philippine archipelago, in accordance with the way the three treaties use this term. First of all, the term archipelago under the UN Convention of the Law of the Sea will not apply because the UN Convention of the Law of the Sea, or UNCLOS, regulates maritime entitlements and does not regulate territory. Under the UNCLOS, archipelago requires a certain ratio of water to land, and at that time of the three treaties, that was not even there yet. No? So the term Philippine archipelago must be interpreted as the term was used and understood in the three treaties. Under the doctrine of intertemporal law, the rights under the treaty must be evaluated in the light of the law contemporary with the treaty, not with reference to the law in force at the time the dispute arose or the time the dispute is settled. Now, there are two kinds of disputes in the South China Sea. You have the maritime dispute and the territorial dispute. The maritime dispute between the Philippines and China has been finally resolved legally by the award of July 12, 2016, issued by an UNCLOS tribunal. The award affirmed the exclusive economic zone of the Philippines in the West Philippine Sea. Vietnam and Malaysia recognized our EEZ in the West Philippine Sea. Only China does not recognize our EEZ in the West Philippine Sea. Now, the territorial dispute remains unresolved because, of course, UNCLOS does not govern territorial disputes, and there is no treaty where an international tribunal has compulsory jurisdiction over the territorial dispute in the South China Sea. We cannot go to an international tribunal that has compulsory jurisdiction. All the parties to the dispute must voluntarily agree to submit the dispute to arbitration, and of course China will not agree to that. So the territorial dispute remains unresolved. Now, what state has the strongest claim to the Spratlys? Scholars have written that the Philippines has the weakest claim because under PD 5096, which lays down the legal basis of the Philippine claim, the grounds that we cited are admittedly weak. First, we said that because of proximity, the Spratlys belong to us. Well, proximity is not a legal ground under international law. We said in the PD, because it's vital to our security and economic survival, that's not a legal ground also. And because it's part of our continental margin or continental shelf, that's not a legal ground also. Because of history, indispensable need, that's not a legal ground. Because of effective occupation and control, that's a legal ground. Because the other countries have abandoned, well, not all countries have abandoned, not all the claimant states. And just because some states have abandoned, like France and Japan abandon or renounce their claim, that doesn't mean that the title goes to us. No? Historical and legal grounds are not legal grounds. So except for effective occupation and control, all the other grounds that we have raised are really weak, and admittedly. But I'm here to show to everyone that we have the strongest claim. We have an ironclad claim to the Spratlys. Now, in any territorial dispute, you start with the critical date. In the Eastern Greenland case between Norway and Denmark, the court said, the Permanent Court of International Justice said that the Norwegian proclamation annexing the Eastern Greenland was a critical date. This was the date when the opposing claims crystallized and the issues were joined between the states claiming sovereignty over the disputed territory. The validity of the claims will be decided based on the law and the facts immediately before this critical date. From the critical date onwards, activities of claimant states to enhance their claim, to improve their claim, are irrelevant. Like if you bring in inhabitants, if you fortify your island, you put up air and naval bases after the critical date, those activities will not improve your legal claim, because the policy of the law is to prevent the aggravation of the dispute. Once the critical date is established, the parties should not aggravate the dispute anymore, because that's the purpose of international law, to provide peace and stability in the air, in the world. No? So the critical date is very important in determining who has sovereignty over the Spratlys. To determine the critical date, let's go to the events. Let's have a look at the timeline. In 1734, we have the Murillo-Velarde map. Spain claimed the Spratlys. It's there in the Murillo-Velarde map. This was reiterated by Spain in the 1808 and 1875 official maps of Philippine territory during the Spanish regime. 1933, France officially annexed the Spratlys as part of the French Union. However, France did not pursue its claim after World War II and effectively abandoned its claim. In 1939, Japan seized the Spratlys and established on Ituaba, the largest island in Spratlys, a submarine base. That base was used in the invasion of the Philippines. But Japan lost the war, and after World War II, Japan renounced its claim to the Spratlys. In 1947, China claimed the Spratlys, but admitted at the same time that the Philippines and Indochina were also claiming the Spratlys. And that, I think, was the critical date. The critical date in the Spratlys dispute arose not later than 1947, when China formally claimed the Spratlys, but at the same time admitted that the Philippines and Indochina had also claimed the Spratlys. This was the date when the opposing claims crystallized. Activities of the claimant states after this date are irrelevant. So all those air and naval bases put up by China will not improve its legal claim, because those activities happened after the critical date. Now, the three international treaties defining Philippine territory are binding on all states that have accepted, consented, or failed to object to these three treaties. Why? Because these three treaties give rise to the international principle of ut possidetis juris, governing the boundaries of former colonies that became independent during the decolonization process. Under the ut possidetis juris principle, these boundaries are sacrosanct and must be respected by all states. The essence of the principle of ut possidetis juris is to secure respect for the territorial boundaries of those states that gained independence during the decolonization process. You know, in Africa, the colonial powers arbitrarily determined the boundaries. You see the straight lines, and tribes could straddle both boundaries. They could be with the French or with the British or with the Italian. So if you start reorganizing the boundaries according to the presence of the tribes, there will be perpetual wars. So internationally developed the principle. Those boundaries are sacrosanct. They must be respected by all countries in order to maintain peace and stability in the world. And that applied not only to Africa, but to South Africa, and also the decolonization, wherever the decolonization process occurred, like in Asia, in the Philippines. So the three treaties establishing Philippine territory were entered into by the colonial powers, Spain, US, and UK. They should be respected under the Uti Possidetis Juris principle as the territory of the Philippines when it achieved independence on July 4, 1946. Now, so to know the extent of Philippine territory that must be respected by all states, we have to know the islands constituting the Philippine archipelago, since the international treaties refer to the Philippine territory as the archipelago known as the Philippine Islands, or the Philippine archipelago. So what are the islands constituting the Philippine archipelago? We start with this map, 1734 Pedro Murillo Velarde map. You will see there Panakot. Panakot is the Tagalog word, the first name ever given to Scarborough Shoal, Panakot. And you will see there Los Baos de Paragua. Paragua was the Spanish name for Palawan. Los Baos means the shoals. The shoals of Palawan are the Spratlys. And if you look at the cartouche here, that is the royal coat of arms of the Crown of Spain, which means that that map is an official map. Because in 1733, King Philip of Spain directed Governor General Tamon to make a map of Philippine territory. And Governor Tamon commissioned Father Pedro Murillo Velarde to make the map. So this 1734 map is an official map of Philippine territory during the Spanish regime. And it shows the Spratlys and the Scarborough Shoal are part of Philippine territory. Now, in 1657, Nicolas Sanson of France, he was the father of French cartography. He was the royal cartographer of King Louis XIII. He made a map of the Philippines. And it shows here that the Spratlys are part of the Philippines. This is 1657. The French acknowledge that the Spratlys are part of the Philippines. And this is another map of a famous French cartographer, d'Anville, 1752. And he was also the royal cartographer of King Louis XV. And he made a wall map of Asia. And you will see Panakot. You will see Los Baos de Paragua. He copied the map of Pedro Murillo Velarde. This is 1752. Velarde made his map in 1734. So he copied it. So the French knew that Panakot and Los Baos de Paragua were part of Philippine territory. Now, why is that important? Because in 1933, France annexed the Spratlys as part of the overseas territories of the French Union on the assumption that the Spratlys were terra nullius, land belonging to no country, because you cannot claim a country that already belonged to another state, a territory that belonged already to another state. However, the French knew or should have known that the Spratlys were not terra nullius, but part of Philippine territory. Their 17th and 18th century maps showed that the Spratlys were part of Philippine territory. So this is the fatal flaw of the French claim to the Spratlys in 1933. The Spratlys were no longer terra nullius in 1933. In 1688, Father Coronelli, the Father General of the Franciscans, made a map of the Philippines. He drew lines around the Philippines, and in the Spratlys, he included the Spratlys as part of the Philippines within the lines. So the cartographers at that time, even in the 17th century, they knew that the Spratlys were part of the Philippines. It's in their maps. How about Scarborough Shoal? In 1792, Alessandro Malaspina came to the Philippines Alessandro Malaspina was the head of the Spanish scientific expedition that went around the world to gather specimens of flora and fauna, and charted the Spanish waters, the waters of the Spanish possessions all over the world. At that time, there was a race among the United Kingdom, France, and Spain. It was a scientific race. It was like sending a man to the moon. At that time, they were exploring the world, charting the waters. And Malaspina came here in 1792. And because in 1748, the British tea clipper ship Scarborough ran aground on Scarborough. That's why the European cartographers renamed it Scarborough. He went to Scarborough. Malaspina went to Scarborough and surveyed Scarborough Shoal. He made depth soundings through this plummet. This is a lead, and attached to the lead is a thin wire. You drop it, and you get the measurement, the depth of the waters there. And this was the first survey of Scarborough Shoal, and this map was the survey that he made. And in his journal on that day, he said, "On this shoal, Spanish and foreign ships have been lost." So we had the first ever survey of Scarborough Shoal. China didn't even know at that time that there was this rock called Scarborough Shoal. In 1808, Spain published a new map of the Philippine territory. At that time, they already have the Dirección Hydrografía. It's a mapping agency, equivalent to our NAMRIA. And the Dirección Hydrografía published this map, and it showed here Scarborough Shoal. They inserted the survey of Malaspina, the 1792 survey of Malaspina was inserted here. A very small rock, and they inserted the survey here. And I will explain why they did that. This is half of the map, the full map. This is the full map. It's a complete map of the Philippines. An official map of Philippine territory in 1808. And at that time, the director of Dirección Hydrografía was Joseph Espinosa. Who was this guy? He was with Malaspina when Malaspina surveyed Scarborough Shoal. He came here with Malaspina, and he was on that Santa Lucia ship that surveyed Scarborough Shoal. That's why he included the survey here. And in this map, you will see already the Spratlys. You can see many of the islands of the Spratlys already included in this map, 1808. Official map of Philippine territory in 1808. Now we come to the most important map, I think. The 1875 Carta General del Archipelago Filipino. This was the last map made by Spain of Philippine territory during the Spanish regime. It was made in 1875, but reissued in 1888 with minor corrections only. The map shows, of course, Masinloc, Bajo de Masinloc, or Scarborough Shoal, and then it shows in detail the Spratlys. It shows Pag-asa, Tito Island, there. That's 260 nautical miles from Palawan. This is the last official map of the Philippines published during the Spanish regime. This is the definitive map showing the islands of the Philippine archipelago. So if you're asked, what are the islands of the Philippine archipelago? We show this map because this is a very detailed map. You can download this map from this website that I downloaded it for free, high-resolution copy from the Ministry of Defense of Spain. Now, this is the same map, but already adopted by the U.S. The U.S. government, when it came here, had to rely on Spanish maps, so they adopted this last map of Spain and reissued it. And you will see here, issued by the War Department Adjutant General's Office, 1901 third edition. So the US adopted and reissued this map 4 times from 1898 to 1902. 1898, 1898, 99, 1901, 1902. But they superimposed the military telegraph lines, cable lines of the military, the Eastern Cable Company's lines, and the military department, but exactly the same map. They just put those lines in red. So if you look at the 3 maps that we have, the Pedro Murillo Velarde map showing Scarborough Shoal as part of the Philippines, that's Panakot. The 1808 map, Carta General, very detailed now with the survey of Malaspina, and the 1875 map with depth soundings now here, further, even further. The depth soundings were made by Captain Montero, I will explain later. China has no similar map that predates any of these 3 maps. Now, we go to the Spratlys. Under the 1875 Carta General map, you will see Tito. Tito is the Pag-asa. You will see Loita, that's Kota, we call it Kota. And you will see Ito-Aba. And this is the edge of the Philippine territory. So the map includes Pag-asa as part of Philippine territory. It includes Kota Island. It includes Ito-Aba. This is the map that should be the frame of reference whenever we are asked what are the islands belonging to the Philippine archipelago. This is the most detailed map. So this is a map made by NAMRIA, our mapping agency. You will see here Pag-asa. You will see here Kota. You will see here Ligao. Ligao is the Ito-Aba. So it follows. That's the line of the polygonal lines of the KIG under PD 1596. That's the edge of the Philippine territory under 1875 line. So this is Pag-asa is here, Kota is here, Ligao is here, Ligao is Ito-Aba. So it jibes. China, Vietnam, Malaysia, they do not have a similar map that predates the 1875 Carta General del Archipelago Filipino. This is a Vietnamese map. They also include Tito Island, Kota, Loita Island, and Ito-Aba here. But you will see here the Spratly. The Spratly is outside the KIG lines. We have not claimed Spratly Island. While in the 1875 Carta General, it's there, but when the PD came out, we did not include it, so we're not claiming it. That's occupied by Vietnam. So, in 2 maps, you have Tito, you have Loita, you have Ito-Aba, Tito, Loita, Ito-Aba. Now, who made this map, the 1875 map? The map was made by Captain Claudio Montero. Captain Claudio Montero, 1875 map. Captain Claudio Montero spent a considerable length of his service as naval officer here in the Philippines. He was, in 1856, he was appointed the head of the newly formed Comisión Hydrográfica de Filipinas, the Hydrographic Commission of the Philippines. Under his direction, the commission published 35 nautical maps. This is one of those maps. You have Manila Bay. You have a lot of depth soundings here. Manila Bay, and you will see Claudio Montero, 1861. So this guy is a very important figure as far as Philippine sovereignty is concerned because he made all of those maps. Now, the Philippine Hydrographic Society Commission under Spain was headed by Claudio Montero, and it had two survey ships in the Philippines, the steamer Reina de Castilla, which Montero commanded, and the Nuestra Señora del Carmen. These ships conducted the depth soundings throughout the Philippines, including the Spratlys. Now, we come to the Treaty of Paris. Unknown to many, the Treaty of Paris had a map attached to it. This is the map of the Treaty of Paris, and this was the map that the US Senate used when they deliberated to ratify the treaty. They were looking at the map, and if you look at the treaty lines, it turns sharply to the west to include the Spratlys. These are the treaty lines. And it includes here Mapon Islands, Sibuto, Cagayan de Sulu. This is the correct map, correct lines. So the Senate, U.S. Senate deliberated, approved the treaty. That's the cover of the map. The map was inserted in this booklet. Jay Batumbakal, Professor Batong, kindly showed me this copy. He took pictures when he went to the U.S. National Archives. And the treaty says Spain cedes to the U.S. the archipelago known as the Philippine Islands and corresponding and comprehending the islands lying within the following lines. So what was ceded under the Treaty of Paris were the islands within the treaty lines. $20 million paid by the U.S. for the acquisition of the Philippine archipelago. But there was a problem. The coordinates in the Treaty of Paris, because the coordinates were there, the geographical coordinates of the lines, did not correspond to the map that the Senate of the U.S. deliberated on, because the lines turned sharply to the east here. It excluded Cagayan de Sulu, Turtle Islands, Sibuto, and it excluded also the Spratlys, excluded Scarborough Shoal. So that was a big problem. So when the Americans, after signing the Treaty of Paris, when they came here, they could not ask the Spanish garrison in Cagayan de Sulu and Sibuto to leave because the Spaniards were saying, oh, we're outside the treaty lines. Spain did not cede Cagayan de Sulu and Sibuto. They refused to vacate. So the U.S. negotiated again with Spain to clarify the treaty lines. And the Secretary, U.S. Secretary of State, wrote the Spanish ambassador in Washington that the intention of the treaty was for all the islands owned by Spain in the Philippines to be transferred, to be ceded to the U.S. And these islands were bounded in the north by Japan, on the south by British Borneo and the Dutch in Indonesia, and everything should be included. But the Spaniards said, you dictated to us the geographical coordinates. We had nothing to do with drawing up the geographical coordinates. We just accepted it. And it's very clear that what was ceded to the U.S. were all the islands within the geographical coordinates. So all these other islands outside the treaty lines were not ceded. So there was several letters, very acrimonious, between the U.S. and Spain. Finally, the U.S. said, we'll pay you another $50,000 just to clarify that the cession included all other islands of the Philippine archipelago. Spain turned it down. They said, that's too little. The U.S. upped the ante. We will pay you $100,000, and Spain said yes. And so there was just one article in the Treaty of Washington drawn in such a manner as to comprehend other islands outside the limits of the Treaty of Paris. So the Treaty of Paris says, this is the wording, Spain also cedes, relinquishes to the U.S. any and all islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. So there was a meeting of the minds. The US and Spain finally agreed expressly that all islands belonging to the Philippine archipelago lying within or outside the treaty lines were ceded to Spain, as to the US. So, what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris? That is the question we have to answer now. What are those islands? Are the Spratlys included in those islands? We go back, to answer that question, we go back to the Spanish maps of Philippine territory, the 1734 Murillo-Velarde map, the 1808, and the most detailed of them all, the 1875 Carta General del Archipelago Filipino. Now, the 1875 Carta General del Archipelago Filipino was adopted and reissued by the US 4 times. In 1898, right after the signing of the Treaty of Paris. The Treaty of Paris was signed December 10, 1898. A few days after that, the US issued the map. Because the US believed that what was ceded to them were the entire islands there in that map. So they reissued it. Again, they reissued it just before the signing of the Treaty of Washington in 1900, 1901. After the signing, they reissued it. And finally, 1902. So this map was the map that the US considered as depicting all the islands of the Philippine archipelago. So an old map that we have forgotten is now reborn as a new star. We have to have a copy of this map. The 1734 Pedro Murillo-Velarde map has been donated by Mel Velarde to the National Library, but we do not have an original of this 1875 Carta General. And these are very important historical documents because they establish Philippine sovereignty. So hopefully we can find a copy of this map and we can give it to the National Library. Now, the 1875 Carta General figured prominently in the 1928 island of Palmas case. In its memorandum, the US submitted the 1875 Carta General map to the arbiter. It was Exhibit 11. And in the memorandum, the US said, this map was exhibited by Captain Montero before this Sociedad Geográfica de Madrid in 1876. 1 year after it was issued, Captain Montero discussed the map before the Geographic Society of Madrid. This map, according to the memorandum of the US, is both an American official and a Spanish official map. It shows the position of the island of Palma. So the US in 1928 said formally before a tribunal that the 1875 map is an official map of the US depicting Philippine territory. And not only the US, it was also an official map of Spain. The map is an important Spanish map showing the island of Palmas as a Spanish possession and a recognition by the US of such island under the Treaty of Paris. So the US said this was the territory that we acquired under the Treaty of Paris. The islands are depicted in this map. So this is a very important map because the US itself said this is Philippine territory that we acquired under the Treaty of Paris and the Treaty of Washington. So if you go to Mindanao, you will see the island of Palmas. This is Sarangani. And the US said that's why the island of Palmas should belong to the Philippines. And of course, Max Huber noted that the maps were submitted. And he said these are official or semi-official maps of Spain or the US, made by Captain Montero. But of course, Max Huber said, yes, the map includes, your map includes the island of Palmas. It was discovered by Spain, but that was just an inchoate title. You had to exercise continuous and peaceful display of sovereignty, and you did not do that. It was the Netherlands that did that, because the Netherlands sent its ships there, and they signed a treaty with the natives, the inhabitants. There are about 750 people living there at that time, and they pledged their allegiance to the Netherlands. So it was the Netherlands that displayed continuous and peaceful sovereignty. That's why we lost the Islas Palmas there in that case. However, Max Huber made a statement that is relevant today. He said, there is a difference between inhabited and uninhabited territory. The requirement of a continuous and peaceful display of sovereignty will not apply to something that's uninhabited, if it's inaccessible. So this applies only, this doctrine of mine applies only to inhabited islands. But he stopped there. 3 years later, the Clipperton Island case came up, 1931. France claimed Clipperton Island an uninhabited island. And a French ship, commercial ship, but chartered for the purpose of going there by France so that the island can be proclaimed as a French territory. So the officer commissioned to do that read the proclamation aboard the ship. They made one landing and came back. And that was it. They went to the nearest island that had a government, the Hawaii at the time, and they published in a 2-by-2-inch advertisement that Spain had proclaimed it as part of French territory. And that was it. And the arbiter in that case said, because Clipperton Island is inaccessible, uninhabited, then that was complete already. The proclamation was complete. And this was further refined in the legal status of Eastern Greenland case, where the court said, since there are no other claimants, and the inland areas of Greenland, the Eastern Greenland, is inaccessible, it's very cold, so you don't have to occupy it actually. So when Denmark colonized the warmer areas of Greenland Island, that was enough to cover the unoccupied territory, because you do not have to occupy areas that are not accessible, that are not habitable. But you can acquire sovereignty over that by just proclaiming your sovereignty, and there are no other claimants. So the inclusion of the Spratlys in the 1875 Carta General, with deft soundings, with specific names, shows a clear intent to possess, own, and exercise sovereignty over the uninhabited and uninhabitable terra nullius islands in the Spratlys. At that time, nobody else claimed the Spratlys. Only Spain was claiming it. From 1734 to 1875, no state had ever claimed the Spratlys except Spain. So, the absence of other claimants, and because the islands are uninhabitable, according to the Arbitral Tribunal of July 12 in the award, it says, the Spratlys is not capable, none of the geologic features in the Spratlys is capable of human habitation based on their own natural resources. There's no historical record of human habitation in the Spratlys. So the mere fact that Spain discovered the Spratlys, put it in their map, made depth soundings, gave it names was sufficient. And you don't have to do anything positive to retain that, according to the Clipperton case. Your rights continue because in the Clipperton case, after proclaiming it as their territory, on a first visit, France never went back until 39 years later when Mexico claimed the island. And so the arbiter said, France, the fact that France has not exercised her authority there in a positive manner does not imply the forfeiture of an acquisition already definitely perfected. Why? Because it's uninhabitable. You don't have to be there all over the time. Okay, so this is the most important map. It is most complete map showing islands belonging to the Philippine archipelago lying outside the treaty lines. Now, in 1938, the Philippine Commonwealth was run by Filipinos, and they were worried that some other country might claim the Scarborough Shoal. And so they asked the Americans, is Scarborough Shoal part of Philippine territory? Because we want to put a lighthouse there, because other countries might claim it. And the Secretary of State, Secretary Hull, replied. He said, because of the absence of other claims, the shoal should be regarded as included among the islands ceded in the Treaty of Washington of 1900. So this was an application of the 1900 Treaty of Washington, that Philippine territory included islands of the Philippine archipelago lying outside the Paris Treaty lines. It was applied in this, in the case of Scarborough Shoal. Scarborough Shoal is outside. So Scarborough Shoal is here, outside the treaty lines. So the Secretary of State of the US said, oh, that's part of Philippine territory because of the Treaty of Washington, or any and all islands lying outside the treaty lines belonging to the Philippine archipelago. Now, in 1930, the US and UK signed a boundary agreement demarcating the boundary between British North Borneo and southern Philippines. And in the whereas clauses, two whereas clauses, they defined the Philippine archipelago as the territory acquired by the US under the Treaty of Paris of December 10, 1898, and the Treaty of Washington of November 7, 1900. So the UK accepted the US, the Treaty of Paris and the Treaty of Washington as forming Philippine territory, all the islands within and outside the treaty lines. The UK accepted that, very clear. Thus, the UK, the US, and also Malaysia as the successor of the UK are bound by this definition, because the UK just inherited Sabah from North Borneo, from Malaysia just inherited North Borneo from the UK. So Malaysia is bound by the two treaties. Now, this is a map drawn by Namria. It's not yet final. Unfortunately, the Treaty of Washington is not mentioned here. You see here, it had all the lines. The Treaty of Paris of 1898, it's here. It veers sharply to the right, excluding now Mapon Island, Turtle Island, and Cagayan de Sulu and Cebuto. And it jumps to the US-UK Treaty of 1930. It skipped the 1900 Treaty of Washington. So I hope that when they finalize this, Namria will include the 1900 Treaty of Washington, which is very important, especially now, because they should include here, explain why we own Cagayan de Sulu and Cebuto and the Turtle Islands, and why we own the Spratlys. They should have another parallel line here showing that these are the island territories lying outside the Paris lines, ceded to the U.S. under the Treaty of Washington, and they should also put here another line to embrace Scarborough Shoal. This is not complete. Now, China published an atlas of ancient maps in China, 1990, 1994, 1990, 3 volumes. It shows all the ancient maps of China. And this was a publication, official publication of People's Republic of China. You have here the 1136 AD map of China and the barbarian countries, showing Hainan as the southernmost territory of China. We presented this map to many maps to the Arbitral Tribunal at The Hague. We said that the Philippines submits the Chinese historic maps dating back to 1136, including those purporting to depict the entirety of the Empire of China, consistently show China's territory extending no further south than Hainan. So throughout the Chinese dynasties, the southernmost territory of China was Hainan. To prove that, we submitted all the ancient maps of China. We submitted the Yuan dynasty, Song dynasty. Yuan dynasty is next. It shows Hainan as southernmost territory. We submitted the Ming dynasty map. Hainan was the southernmost territory. And the last dynasty was the Qing dynasty, and it shows Hainan was the southernmost territory. What is the value of all this? Now, the general rule is maps cannot establish title to territory. We all know that. However, there are exceptions. When the map is attached to a treaty, then that will bind the parties to that treaty. Also, when the map is unilaterally produced by a state, even if not attached to a treaty, it can bind the producing state if adverse to its interests. In Pedra Blanca arbitration between Malaysia and Singapore, the International Court of Justice held the map still stands as a statement of geographical fact. It's a statement of geographical fact when the state adversely affected has itself produced and disseminated the map even against its own interest. Here, Malaysia produced a map, disseminated it, showing that Pedra Blanca belonged to Singapore. It was unilaterally done by Malaysia. So the court said, oh, that's an admission against interest, and you're bound by that. All these maps of China showing that its southernmost territory was Hainan throughout the Chinese dynasties are admissions against interest, and China is bound by this. Now, today, China bans the exports of map of China, ancient or new, without the 9-dash line. Chinese customs seized thousands of maps over the missing South China 9-dash line. South China's 9-dash line. If you look at this map, this is a Tang Dynasty map, 669 AD. That's about 1,300 years ago. What China did was to reproduce the map and insert the 9-dash line here. At the lower right-hand portion, you see the 9-dash line. With this map, you can now export it. So they will seize your... Luckily, I was able to buy those 3, the Atlas of Ancient Man's China, before the ban. Now, I bought that from eBay. Now, when China was under the Kuomintang, under the Republic of China, the Kuomintang issued this book, and the People's Republic of China reissued it on January 1, 1919. Regulations of the Republic of China concerning the rule of Tibet. China published this because China was trying to prove to the world that Tibet belongs to China. And during the Qing Dynasty was the largest expansion of Chinese territory. During the Qing Dynasty, Tibet, Xinjiang were part of China. So it is said, Tibet belongs to us because that was under the Qing dynasty, that was part of the territory of China. So it says here that in the first Constitution of the Republic of China, it says there, the territory of the Republic of China continues to be the territory of the former empire. And in the editorial comment of the book, the editor said the former empire refers to the Qing dynasty because it was the largest expansion. Unfortunately, during the Qing dynasty, the southernmost territory of China was Hainan. So they're bound by that also, because they're saying our territory was always the territory of the Qing. But the Qings, you look at all the maps of the Qing dynasty, it ended in Hainan as far as the South China Sea is concerned. So there are 4 constitutions of China during the Republic of China, and all of them said that our territory is the traditional territory, the territory we own in the past, the traditional boundaries, all referring to the Qing dynasty. And China is bound by those declarations. You know, the Chinese always tell us, Philippine territory is governed by the 1935 Constitution of the Philippines. There are 3 treaties there, and all your territories must be within the Paris Treaty lines. We agree, because they thought that the Paris Treaty lines was the final agreement. They keep on mentioning the Treaty of Washington without reading the text. I will show that later. So we tell China, okay, fine. Let's decide this case based on Philippine Constitution and Chinese Constitution, because they will be bound by their own constitution that the southernmost territory of China was Hainan throughout the Chinese dynasties. That's Hainan. Now, if you go to the Paracelsus practice, you see these stone markers erected by China in 1902, erected by China in 1911, during the Qing dynasty. The Qing dynasty ended in 1912. You see them all over. They're all fake. I have a friend, Francois Vierbonnet. He showed me a book. He said he copied he said, these are all fakes. Look at this book. You know, in 1987, China produced a book made by the Guangdong province. They had a committee explaining why their islands in the South Sea, Nanhai means South Sea, South China Sea, why those islands were named the way they were named. So they made this book. But that book contained an interesting annex and editor's note. As a background, in 1937, June 1937, the Kuomintang sent Wang Xiang to the Paracels, and it was announced that he was going to the Paracels to check reports that the Japanese have invaded the Paracels, and he will be sent there also to assert Chinese sovereignty. That was the cover. But he had a secret mission, and he made a report of what he did under his secret mission. He made a confidential report. He said, I went there in June 1937, and I planted markers dating 1902 and 1921. Commemorating the inspection of 1902. He was there on 1937. Commemorating the inspection of 1902. He was there in 1937. Commemorating the inspection of 1911. He placed it many places in many islands. And when the book was about to be published, a lowly clerk saw the confidential report and said, this should be included in the book. And it was included in the book. And so, my friend here, he showed me a copy of the book. He said, all these stone markers are fake. So I asked a friend who frequented Manila and Beijing to look for a copy of this book in second-hand bookstores in Beijing, and he found a copy. I have that copy. That's it. And after that, the Chinese authorities withdrew all copies. You can't find this anymore. But those markers are all fake. And how about this marker in the spat list? There is a note also in the book, page 291 of the book, which says, the stone tablets on these two islands might have been erected by the Taiwanese Navy in 1956, not in 1940. Why 1956? Because the Kuomintang sent a ship to the Spratlys. They landed in Ituaba, the largest island. That ship, named Taiping, was an ex-U.S. Navy destroyer escort, the USS Decker, donated by U.S. to the Kuomintang. They went there and he placed a marker erected in December 1940s. But he did not go to the other islands. So when he first saw the book, he went to the editors. He complained, look, I was the captain of that ship that went to Ituaba. We did not go to the other islands. We did not plant that in December 1946. So the editors subsequently made a note, editor's note. The stone tablets on these two islands in Spratly Island and in Westward Island might have been erected by the Taiwanese Navy in 1950. Why 1956? Because, as I said, the Kuomintang went there in 1946. They established a garrison there. But in 1949, Chiang Kai-shek recalled the troops in Ituaba to go back to Taiwan because there was a possible invasion by the Chinese of Taiwan. 1949, the Chinese threatened to invade Taiwan. So he recalled the troops. And they returned to Ituaba only in 1956 as the Taiwanese Navy. That's why the editor said, oh, those two tablets might have been put up there by the Taiwanese Navy when they returned to the Spratlys in 1956. So, all fake. Now, in 1887, France and China signed a boundary agreement between in North Vietnam because France was the colonial power in Vietnam, the entire Vietnam at that time. And they made a treaty demarcating the boundary. And it says the isles which are to the east of the meridian, so and so, are similarly assigned to China. Based on this provision, China claims France ceded the Paracels and the Spratlys to China. So this is the boundary line. The islands here, according to the French, were ceded to China. But the Chinese now are saying, oh, because of that provision, we also own the Paracels and the Spratlys. So the French sent a note verbal to China that that boundary treaty was applicable only to the Mangke area in northern Vietnam and did not apply to islands several hundreds of miles away from the delimitation line. In fact, the 1887 boundary treaty never mentioned the Paracels or the Spratlys or any island in the South China Sea. More importantly, in 1887, France had not even claimed the Paracels and the Spratlys. France claimed the Paracels in 1932 and the Spratlys in 1936. So France could not have ceded in 1887 territory that France never claimed or possessed in 1887. Neither had China claimed the Paracels or the Spratlys in 1887. In 1932, France occupied the Paracels, and the Chinese protested. China sent this protest, this note verbal. China said, there are two groups in the Paracels, the Amphitrite group and the Crescent group. These groups lie 145 nautical miles from Hainan and form the southernmost part of Chinese territory. 1932, China told the world, our southernmost territory are the Paracels. These are the Paracels, 326 nautical miles from Scarborough Shoal, 405 nautical miles from the Spratlys. Very far. China is bound by its 1932 note verbal that the Paracels are its southernmost territory. So, during the dynasties, this was the southernmost territory of China up to 1912. China expanded to the Paracels, 1932, claiming the Paracels, Now it's claiming the rest here. Now, if you go to the Chinese embassy website in Manila, you will find this claim of China that justifying why they own Scarborough Shoal. Because China said in 1279, during the Yuan dynasty, Gu Sujing built an astronomical observatory on Wangyan Island. Wangyan is their name for Scarborough Shoal. It shows that Wangyan was part of China during the Yuan dynasty. So that's their claim. You go to their website. That's the screenshot of their website. However, when China and Vietnam were quarreling over the paracels, in 1980, China published this article that they have sovereignty over Xia and Zhongya Islands, and because Gu Sujing established his astronomical observatory in the paracels. You know, Gu Sujing is the most famous mathematician, engineer, astronomer of China in its history. He built canals. He built 27 observatories throughout China, one in the South China Sea, 26 in mainland China and Hainan. So the question is, where did Gu Sujing put up this observatory in Nanhai, South China Sea, South Sea? In 1980, China said, oh, Gu Sujing erected his observatory in Xia, the paracels. That's why we own the paracels since 1279. But today we are quarreling with China over Scarborough Shoal. China is saying, oh, Gu Sujing erected his observatory in Scarborough Shoal. He put up only one observatory in the South Sea. So here, the astronomical observation point Nanhai is today's Xia Island. It shows that Xia Islands were within the bounds of China at the time of the Yuan dynasty. So they used this argument against China in 1980. Now they're saying the same thing against us. And they published this in Beijing Review, an official publication of the Ministry of Foreign Affairs of China. China is bound by its 1980 declaration. It is stopped from claiming that Gu Sujing erected the observatory on Scarborough Shoal. China has no basis at all to claim Scarborough Shoal. Very far, 326 nautical miles, Gu Sujing was a brilliant. He was, I think he was as brilliant as Leonardo da Vinci. He was multi-talented. He built canals, observatories, but he could not have missed it by 326 miles, nautical miles. Now, of the 26 observatories that Gu Sujing built in China, one still exists today in Henan. It's huge, 12.6 meters high, and there's a sundial, maybe another 12 meters, and that's Scarborough Shoal. Maybe 6 to 10 people could stand on that shoal. So it was physically impossible. You know, you have to operate this observatory every day because you have to take measurements, sunrise, sundown, because Gu Sujing was instructed by Kublai Khan, the first emperor of China, to make a calendar because they wanted to know when the seasons would begin and end. So for purposes of planting, you must know when the season will come so you can plant and harvest. And this guy created a calendar more accurate than the European calendar. And even up to this date, he just missed about less than 100 seconds. Could he have built those? It's impossible. So legally, China cannot claim. They're stopped. They already said, use this argument against Vietnam in 1980. Physically, it's also impossible. In 1933, France claimed the Spratlys, 6 islands in the Spratlys. So in 1932, France seized and claimed the paracels. The following year, France claimed the Spratlys. Officially, China did not protest this claim of France of the Spratlys, since China never claimed the Spratlys in the past. Besides, China in 1932, the year before, just announced to the world that our southernmost territory are the Paracels. They could not change it the following year and say our southernmost territory are the Spratlys. So they kept quiet. They never protested. Now, the Vietnam claims that it succeeded France to the Spratlys claim. Said, we are the successors of France. However, the French dispute this. The French foreign minister said these islands were not attached to Vietnam. They were administered by the Ministry of Overseas France. In 1955, the French foreign minister again clarified in another note that beyond doubt that the Spratlys belong to the French Union, not to Vietnam. So Vietnam cannot claim the Spratlys as successor of France. Besides, if you are part of the French Union, the inhabitants of that territory are French citizens automatically. They can vote in French elections, vote for the French presidency. The people in Vietnam are not French citizens. They cannot vote in French elections. So if the territory is declared to be an overseas territory of the French Union, they are territory of France itself, just like Paris, just like any other territory. In 1943, China, under the Republic of China, published a book, the China Handbook, and it was an announcement to the world about China. And China stated that our territory extends this way. In the South China Sea, our southernmost territory is Triton Island of the Paracel Group. So, 1943, China did not yet claim the Spratlys or Scarborough Shoal. They only claimed the Paracels. Triton is the island in the Spratlys nearest to Vietnam. That was their farthest claim in the South China Sea. 1943 already. But they revised, that's the book that they published. I was able to get this also in eBay. But of course, you cannot buy this anymore. 1947, China revised its handbook. And for the first time in history, China claimed the Spratlys. These are the Spratlys, the Coral Islands. On the south, we claim the Coral Islands, the Spratlys, but these are also contested among China, the Commonwealth of the Philippines, and Indochina. So when China claimed the Spratlys, China realized and expressly acknowledged that the Philippines had a pre-existing claim. So this is an admission that the Spratlys were not terra nullius. You can only claim if it's terra nullius. There was already a claimant. That's the book. And there is the supplement, 1946. They included a supplement precisely to claim the Spratlys. Now, the reason for the supplement, as I said, the U.S. donated the ship, the USS Decker, to China. It's a destroyer escort, and China renamed it the Taiping, the Kuomintang, under the Kuomintang. And they sent this to Ito Aba on December 12, 1946. It arrived, and the sailors there erected at the marker, stone marker, erected in December 1946. For the first time in its history, China claimed the Spratlys in its 1947 China Handbook. And that's why they added this supplement. It was too late in the game. So China knew that the Philippines had a pre-existing claim. How did China know about this? Well, this is my guess that, during the civil war between the communists and the nationalists in China, and during the Japanese war, the U.S. sent hundreds of military advisors to Chiang Kai-shek. And of course, those U.S. military advisors would be familiar with the maps issued by the U.S. War Department, and probably that's how the Chinese learned about the Spratlys from the maps of the U.S. War Department, and one of these maps is the 1875 Carta General. In 1947, China published this infamous 9-dash line map, 1947. And it contains names of the paracels, of the Spratlys rather. But the names are just transliterations of English names found in British maps. So they were able to give names to the Spratlys, but they just copied, transliterated into Chinese the English names. But in the Scarborough Shoal, they had no name for Scarborough Shoal. 1947 already, they still couldn't give a name to Scarborough Shoal. China is always saying, we were the first to discover, first to name the islands in the South China Sea. 1947, they still didn't have a name for Scarborough Shoal. And this is the map on which they based their claim to the Spratlys and Scarborough Shoal. So, China, according to Bill Hayton, China probably took those names from the China Sea Directory published by the UK Hydrographic Office in 1906. For example, you have here Lucunya Shoal, Luconia. James Shoal, Jengmu. So it was just transliterations. Now in Scarborough, we gave it a name, Panakot, in 1734. The Europeans renamed it Scarborough Shoal. 1947, in China's map, they still have no name. According to Bill Hayton, the Chinese gave a name later to Scarborough Shoal, but it was a transliteration, Sikabulu. They just named it, transliterated it after the name Scarborough. Now, China, under the Kuomintang, briefly occupied Ito Aba, as I said, in 1946. Until 1949, they went back in 1956. In 1987, the People's Republic of China occupied Fiery Cross Reef, and telling the world we are occupying Fiery Cross Reef to establish a weather station to help UNESCO in its Global Oceanic Survey. That was their cover. They said, oh, don't worry, we are just putting up a weather station. Today, Fiery Cross Reef is an air and naval base of China. They occupied also Mischief Reef in 1995. I was in Malacanang at the time. And, but China said, don't worry, this is just a fisherman's shelter. Today, it's the largest air and naval base of China in the South China Sea. They call it our Pearl Harbor in the South China Sea. Now, when did we occupy the Spratlys? Well, we occupied it in late 1960s and 1970s. Why did we not occupy it earlier? Because it was not habitable. We were not required under international law to occupy it. The tribunal said it's not habitable. So all we did was to go there now and then, patrol it, and that's enough. Under the Clipperton Island case, we don't lose. We don't have to do anything positive to maintain a title, to a sovereign title that was already perfected. Vietnam first occupied the Spratlys in 1975. The North Vietnamese took over from the South Vietnamese because when the South Vietnamese were expelled from the Paracels, the South Vietnamese transferred to the Spratlys. That was 1974, and they lost the Battle of the Paracels to the North Vietnamese in 1974. So shortly after that, in early 1975, they seized about six features in the Spratlys, but they were thrown out by the North Vietnamese a few months later. But these occupations are beyond the critical date. The critical date was 1947, so whatever they did after that had no value as far as the legal title is concerned. Now, when China lost the arbitration at The Hague, China doubled down in its false claim. China said, under the Cairo Declaration, the Spratlys and Paracels were awarded to China. Under the Potsdam Declaration, the Spratlys and the Paracels were also awarded to China. Under the San Francisco Peace Conference, the Paracels and the Spratlys were also awarded to China. Under the Taipei Treaty, the Paracels and the Spratlys were also awarded to you. All false. the Cairo Declaration says all the territories that Japan has stolen from China shall be restored to the Republic of China. There was no mention of the Spratlys or the Paracels. Did Japan steal the Spratlys or the Paracels from China? No. Japan seized the Paracels in 1939 from the French, which occupied the Paracels in 1932. Japan seized the Spratlys in 1939 from two countries, from the Philippines, which had claimed the Spratlys since 1734, and from the French, which annexed the Spratlys in 1939. In 1939, when Japan seized the Spratlys, China had not even claimed or was not in possession of the Spratlys, as clearly shown in both the 1943 and 1947 China Handbook. So how could the Cairo Declaration, the Potsdam Declaration, restore to China the Spratlys when China never occupied, never claimed the Spratlys as of 1939? China claimed the Spratlys only in 1947. The Potsdam Declaration merely reiterated the Cairo Declaration. The 1951 San Francisco Peace Treaty had the powers represented there, many countries. There was a motion by the USSR to award the Spratlys and the Paracels to China. That motion was defeated by a vote of 46-3 with one abstention. So the San Francisco Peace Treaty, which put an end to the war in the Pacific, clearly refused to award the Paracels and the Spratlys to China. They was put to a vote. China lost overwhelmingly. That's why China denounced the treaty as illegal. So how could it claim that something from that treaty when it denounced it as illegal? In 1952, April, Japan and Republic of China signed a peace treaty, but it merely recognized the San Francisco Treaty. It is recognized that under Article 2 of the San Francisco Peace Treaty, Japan has renounced all right, title, and claim to Taiwan, Penghu, as well as the Spratly Islands and the Paracel Islands. Full stop. There was no award. So the Taipei Treaty expressly recognized the San Francisco Treaty. Now, the San Francisco Treaty was signed on September 8, took effect on April 28, 1952. The Taipei Treaty was signed on April 28, 1950, took effect August 5, 1952. Whether from the date of signing or from the date of effectivity, the San Francisco Treaty takes precedence over the Taipei Treaty. In short, when the San Francisco Treaty took effect, more than 3 months prior to the effectivity of the Taipei Treaty. So there's no way that China could say that the Spratlys were awarded to China under the Taipei Treaty, because Japan already renounced it in the San Francisco Treaty a year before. It could not change its mind and then give it to China. It was put to a vote, and that vote, China lost that vote. The Chinese official position of Philippine territory, they always say, Philippine territory is regulated, governed, defined by 3 treaties. The Treaty of Paris of 1898, the Treaty of Washington of 1900, and the Treaty with the British of 1930. Foreign Minister Wang Yi, in his lecture at the CSIS Washington, a leading think tank Washington, reiterated that the Philippine territory is regulated by 3 treaties, and Wangyan Island is outside the treaty lines. The Spratlys are outside the treaty lines. So he said, see, you Filipinos, you just read your constitution, and you will see that the islands there that you claim are not within your territory. You go to the Chinese website, the same claim. Philippine territory is regulated by 3 treaties. You go to the Chinese Foreign Ministry website, the same claim. They even quote the national territory provision of the 1935 Constitution. In the arbitral proceedings at The Hague, China did not participate, but it submitted a position paper. In its position paper, China reiterated that Philippine territory is governed by 3 treaties. under their 1935 Constitution, they quoted the 1935 Constitution. Therefore, officially, judicially, China admits that the territory of the Philippines is governed by the Treaty of Paris, the Treaty of Washington, and the treaty with the British. But they did not read the Treaty of Washington. They didn't even bother to check the history. Why was the Treaty of Washington made? They did not read the text. Any and all islands lying outside the treaty lines. Because when they see the Paris Treaty lines, that's when you go to the internet, that's all you see, the Paris Treaty lines. And some of our professors, even law professors, have been saying Philippine territory is limited to the Treaty of Paris lines. Everybody forgot about the Treaty of Washington. Even Namria forgot about it, up to now. By officially submitting its position paper to Arbitral Tribunal, China has expressly, formally, and judicially recognized and admitted that Philippine territory is governed by three treaties, including the 1900 Treaty of Washington. China is stopped. The other day, China again repeated this, that the Philippine territory is governed by three treaties. They again repeated it. They made an announcement, the Minister of Foreign Affairs, China. Up to now, the Treaty of Washington is very clear. Any and all islands belonging to the Philippine archipelago lying outside the lines. To answer the question that I raised at the start of this lecture, what are the islands? We must refer to the 1734 Murillo-Velarde map, the 1808 Carta General, and the 1875 Carta General del Archipelago Filipino. Our strongest legal basis, the Treaty of Washington and the treaty with the British. All these treaties are recognized by China, the US, Spain, UK, and Malaysia. China already recognizes the Treaty of Washington of 1900. So the last question, did we ever abandon, did the US or the Philippines ever abandon our sovereignty over the Spratlys? We have to look at this. This is the last question that we have to ask. Well, we go to the timeline. 1734, 1808, 1875, there's no abandonment, no waiver there. You go to the 1898 Treaty of Paris, 1900 Treaty of Washington, 1930 Treaty with the British, there is no abandonment there. At this point, the uti possidetis juris already applies because our boundary has been fixed by international treaties of the colonial powers. 1932, France claimed and annexed the Spratlys, but effectively, France abandoned it, so that's nothing. France gave up. 1935, the Philippine Constitution restated that our territory are governed by the three treaties. At this point, in 1935, Philippine territory could no longer be ceded or abandoned by the US. Why? The ICJ opinion in legal consequences of the separation of the Chagos Archipelago from Mauritius holds that the colonial power cannot detach a territory of the colony that is about to be independent. And then in 1935, we were about to be independent. If you cannot detach, you cannot abandon. 1938, the US State Department affirmed that the Treaty of Washington of 1900 included all islands lying outside the treaty lines. 1939, Japan occupied the Ituaba. The US did not protest. But our people here in Manila protested. I saw the articles. But Japan lost the war. And if it lost the war, its occupation was illegal. Before the 1945 UN Charter, the rule was might was right. You can, if you want to annex the territory of your neighbor, go to war. If you win, you are the legitimate owner. If you lose, your action was illegal. The action of Japan was illegal here. 1947, China claimed. But then China admitted that it was also claimed by the Philippines. And therefore, the Spratlys were not res nullius, not terra nullius. 1951, Japan renounced its claim, so the invasion of Japan really didn't matter. 1973, the Philippine Constitution reaffirmed our territory as the Philippine archipelago. 1975, Vietnam first occupied the islands, but that is way after the critical date. And besides, France abandoned its claim. 1978, we created the municipality of Kalayaan. There's no abandonment here. So, in conclusion, what is the Philippine archipelago? It's all the islands lying within the lines of the Treaty of Paris, all the islands lying outside the lines of the Treaty of Paris, as clarified in the 1734 Murillo-Velarde map, the 1808 Carta General, and the 1875 Carta General, the Archipelago Filipino, plus the demarcation agreement with the UK. So my recommendation at this point is the Philippines should invite China, Vietnam, and Malaysia to submit the territorial dispute in the Spratlys to voluntary arbitration by the ICJ. Separately, the Philippines should also invite China to submit the territorial dispute over the Scarborough Shoal to voluntary arbitration by the International Court of Justice. This will finally settle by peaceful means, as mandated by the UN Charter, the territorial disputes in the Spratlys and Scarborough Shoal. Why? Because the UN Charter says all disputes between states must be settled by peaceful means, by negotiation, mediation, or arbitration. You cannot use threat of force, or you cannot use actual force to settle any dispute between states. Now, if the disputant states are not willing to submit the territorial dispute or to arbitration, then we just wait for sea level rise to submerge most, if not all, of these islands. And once they are submerged, they will form part of the 200 nautical mile EEZ of the Philippines, measured from our archipelagic baselines. Beyond that, they will form part of our extended continental shelf. So I end my presentation here. Thank you for your patience.
Thank you very much, Justice Carpio. Let's please give Justice Carpio one more round of applause. To end this morning's proceedings, we would like to call Professor Fina Tantuico, the Corporate Secretary of the Justice George Malcolm Foundation, to give the closing remarks.
It has indeed been a very productive morning. What with the wealth of information we have imbibed from our esteemed speaker, whose love for country knows no bounds. Thank you, Justice Carpio, for all that you do for our country. May we have a round of applause again for Justice Carpio. For the students here present, I'm sure that years from now, you will remember this historical lecture. Justice Carpio chairs the Malcolm Foundation, which traces its roots to the fund entrusted by UP Law Dean's founder and first dean, Justice George Malcolm. The Malcolm Foundation was formed to foster and promote studies and continuing interest in constitutional law, to aid in financing a professorial chair in constitutional law, and to administer the Malcolm funds. On behalf of all the other trustees of the Malcolm Foundation, Justice Leonen, Justice Chit, Chair Grace, Dean Agabin, and former D&D Secretary Avelino Cruz Jr., who should have been here to give the closing remarks, we thank everyone present here today, whether in person or online, for gracing this occasion. We thank deeply with all our hearts the staff of Senior Associate Justice Carpio, the student volunteers from UP Law, Diliman, sections 1B, 1C, 1J, and 1 BGC evening. Are you all here? Staff of the Office of the Dean, Office of the College Secretary, Law Center, and Maintenance, the Information and Publication Division, led by Professor Mike Tew, the Communications Group, led by Attorney Martin Esguerra, Ms. Sara Asas, Joanna Morales, Benedict Casino, Oliver Wendell Amazona. Last but not least, the Foundation would like to especially thank Associate Dean Sol Lumba, Professor John Molo, Chair of the Constitutional Law Cluster, and most especially Professor Paulo Tamase, ang aming pong guwapong punong abala, for making this activity possible and very productive. So with that, we thank you all once again for this morning's for your attendance for this morning's activity. Maraming salamat po.
Thank you very much, Professor Fina Tantuico. This concludes the Magister Lecture on the Philippine Islands in the West Philippine Sea. Thank you for attending today's event, and we hope to see you in future lectures of this series. We can continue our conversation around the lecture of Justice Carpio over lunch. We might not be able to accommodate everyone, but we invite the trustees of the Malcolm Foundation, invited guests of Justice Carpio, faculty members, and members from foreign missions. You may exit on the left side of the stage and proceed to the faculty lounge for lunch, while all other guests, including those from the media, AFP Coast Guard, editors of the Philippine Law Journal, overflow from the faculty lounge, and other guests, you may proceed to the right side of the stage. Lunch will be served at the Ambion Room. For on-site attendees requiring certificate of attendance, please sign up again at the registration area at the lobby so that you can get your certificates. I'd like to thank everyone for attending today's session, and once again, let's thank Justice Carpio for a very brilliant and historical lecture.